Ready, start. Learned advocate for the petitioner has requested not to observe anything on merits and therefore, we refrain from observing anything on merits. The reasons given by the petitioner assessee for not filing return of income before due date, even for assessment year 2013-14, full stop. In view of the above and for the reasons stated above, the impugned order passed by the respondent number 1 rejecting the compounding application submitted by the petitioner cannot be said to be either illegal or contrary to the guidelines, we see no reason to interfere with the same, full stop. In view of the above and for the reasons stated above, present petition fails and same deserve to be dismissed and is accordingly dismissed. Full stop. In such circumstances referred to above, the appellant is here before this court with the present appeal. Full stop. He submitted that an offence as contemplated under section 276 cc of the Act is committed upon the failure of the assessee in furnishing the return of income within the due date as contemplated under section 139 within bracket 1 of the Act. Full stop. He submitted that whether the assessee had filed a belated return of income, that is, after the expiry of the due date or not, is immaterial, and the point in time when the offence under section 276 cc is committed is the date immediately following the due date for furnishing the return of income as prescribed under section 139 within bracket 1 of the Act. Full stop. Thus, for the assessment year 2013-14, the appellant could be said to have committed the offence on the date immediately following the due date for filing of returns for the assessment year 2013-14, full stop. Hence, the date for commission of the offence under section 276 cc for the assessment year 2013-14 would be 1/11/2013 as the due date for filing the returns for assessment year 2013-14 was 31/10/2023. Full stop. He emphasized on the fact that the actual date of filing the belated return is of no consequence for the purpose of an offence under section 276 cc, as otherwise an assessee who has missed filing the return before the due date for a given assessment year would never file a belated return and the offence would never be committed. Full stop. He further submitted that as per the 2014 guidelines, the expression first offence means offence committed prior to the issuance of so-called notice seeking to initiate prosecution, as that is the earliest point in time when the assessee is put to notice about the offence alleged to have been committed by him. Full stop. Once an assessee is put to notice, all offences alleged to have been committed thereafter are not compoundable. Full stop. However, offences committed prior to the date when the assessee is put to notice, would be treated as constituting the first offence and hence would be compoundable. Full stop. He submitted that in the facts of the present case, two so-called notices were issued against the appellant by the respondent authorities, one for assessment year 2011-12 issued on 27/10/2014 and the other for assessment year 2013-14 issued on 12/3/2015. Full stop. He argued that the High Court erroneously relied upon the actual date of filing of return of income for the assessment year 2013-14 to hold that the offence for the said assessment year was committed after the first so-called notice in respect of assessment year 2011-12 had already been received. Full stop. He submitted that it is not the date of actual filing of the belated return of income but the date immediately following the due date for filing of return for the given assessment year which should be considered while determining whether the offence is a first offence as per the 2014 guidelines. Full stop.